Beware of the trial attorney who reads from a script. You want to learn what I mean? Come join me. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Let me give you an example. May it please the court. My name is Gerry Oginski. I am a New York medical malpractice attorney practicing law. I represent John Jones in this case. What does that sound like? It sounds like the attorney doesn't know what they're talking about, right? It sounds like the attorney has to rely on a written script to give them an idea of exactly what they need to say. Ideally, you want an attorney who knows your case inside and out. And the reason you want that to happen is because the attorney who has experience will typically not be relying on any script. You may find attorneys who rely on outlines, and I know good attorneys who do that all the time. But there are attorneys who simply don't even rely on notes. When you see an attorney at trial who doesn't use notes, who doesn't use outlines, it may seem like they're just doing it off the cuff, but I guarantee you they have spent hundreds and hundreds of hours practicing, understanding their trade, understanding the case, so that now when they get up in front of a jury, they can have an intelligent conversation, and it appears so natural, like we're doing right now. At trial, an attorney who diverts their eyes away from the jury and now starts to read their notes in their notepad, what happens is they lose that connection to the jury. A trial attorney typically will go up to the jury box and talk to and look at the different individual jurors. And as they are talking, they will connect with each one of them with their eyes. And that's an important psychological component of creating a compelling answer and compelling reason why your client needs to be awarded a decision in your favor. And that's critical. Because if you never look at the jury, how will you get them to trust you? How will you get them to trust your client and what you have to say is credible? So it is very important from a psychological perspective to make eye contact with the jury. And the only way to do that is to look them in the eye and to talk to each one of them during the course of the openings and closing remarks. So when you see an attorney stand up before you and read from a script, you know that they may not be as experienced as you'd like them to be. Now, why do I tell you this information? I tell you this just to give you an insight and an understanding into how these types of cases and trials work here in the state of New York. And chances are you're watching this because you have questions about your particular matter. Well, what I encourage you to do is pick up the phone and call me if you have legal questions. I answer questions like yours every single day, and I'd be happy to talk with you. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski. Thanks so much for watching.